Welcome to Inside IR, a podcast series by Herbert Smith Freehills that explores the latest developments in the Australian industrial relations landscape.
Hello and welcome to Inside IR, the Australian Industrial Relations podcast, the series that arms HR, IR and legal professionals with the latest industrial relations thinking. My name is Rohan Doyle. I'm a partner in the Industrial Relations team at Herbert Smith Freehills. And joining us today on the Inside IR couch is Executive Counsel Lucy Boyd and partner Tony Wood. Welcome, team.
Hi, Rohan.
Thanks, Rohan. Good to be here. First time. Very excited.
Yes, and you're back in Melbourne, of course. About 3 or 4 years ago, you were in London within
That's right.
HSF.
Had a few years there, but started here in Melbourne many years ago now. So, good to be back.
Good to have you
couch.
back home, and very much looking forward to your insights on Inside IR today. And Tony, you're a bit more experienced on Inside IR, your third appearance, I think.
I'll do my best, Rohan, to meet your very high expectations.
Fantastic. Do you have any statistics for us today? You normally come to us with some
I
nice
will have some
graphs
data.
and charts.
I'll have some data that we can talk about later.
I look forward to that. But we do have another very important episode of Inside IR today. It is our second episode in our series on the Closing Loopholes Bill. We're going to need a few more on top of this as well to get through the 270-odd pages and the 28 distinct parts of that bill. But just to recap on where we're at with that bill and set the scene. So we know, as at the time of filming, the Senate has referred the bill to the Senate Education and Employment Legislation Committee for an inquiry, and very tight deadlines have been imposed for written submissions as part of that inquiry. But the reporting deadline has been pushed out until the 1st of February 2024. So what that means for us is that we're not going to have an act at least until after that date. So we'll be talking February, March, April into the new year. But importantly, despite that delay, one very important thing that we're telling our clients is please don't make the mistake of thinking that that means you can ignore this, not worry about it until the new year if and when it passes. The reason you can't ignore it is because there are aspects of the bill that, if it does actually pass, regulate conduct that's occurring right now. So we spoke during our previous episode on same job, same pay about the anti-avoidance provisions. That applies, if it passes, to conduct from 4 September 2023. So employers in particular, hosts, need to know those obligations now. But on top of that, and we'll be covering some of this today, some really serious changes that are going to impact how businesses resource their workforces. And those changes are going to require some serious thinking and planning well ahead of commencement. So if this legislation does commence in the new year, it's going to come up very quickly, and it's going to require some really solid advanced planning well ahead of commencement for businesses to really survive and thrive in this new world of IR. So as we've said in our previous episode, we have produced a comprehensive summary on the bill. Google HSF and closing loopholes, and you'll have the link to that pop up. So do have a look at that. That'll give you some really great insights to what legislation will do. But again, as we mentioned on our previous episode, there's really 7 big ticket items that we need to be aware of in the bill. The first is same job, same pay orders, and the second are the new minimum conditions that will apply to regulating non-employees in the gig economy and in the road transport distribution sector. Those first 2 topics we covered in our previous episode of Inside IR. We also covered the new Fair Work Commission jurisdiction to challenge unfair contracts. It's number 3. Number 4 is the new federal criminal offence for wage theft and some changes to the penalties regime for non-compliance. We'll deal with that in a future episode of Inside IR, which leaves us with the remaining 3 of those 7, and they are the new casual employee definition, the new definition for working out whether a worker is an employee or contractor, and the new workplace delegate rights. And those are the 3 topics that we're going to cover on the episode today. Now, a common theme with those 3 changes, Tony, Lucy, I think is uncertainty. And it'd be good to reflect on that as we go through these topics today. We are moving in each of those 3 topics. We're moving from a scenario where I think employers, businesses, we're all pretty clear on the tests. We're clear now, generally speaking, who is a casual, who's an employee versus a contractor, what rights employees and delegates have in the workplace. And I think on each of these topics, we're moving to tests that are multifactorial and frankly are going to be quite unclear. They're going to be unclear for even seasoned practitioners that are very experienced in this space. And personally, I worry about the standard sort of medium to even larger sized business and their capacity to actually apply these new provisions and act with confidence that they're affording their workers with the requisite minimum conditions required by statute. So there's some important themes that I think we should touch on today.
But Rohan, it's not a lack of clarity that is new in a sense, is it? I mean, it's going back to what we had for many years. I mean, in relation to what is a casual employee or what's an employee, we've always had that confusion and uncertainty and the lack of any definition necessarily in the Act until, the High Court cases, of course. I think, Lucy, you'll be dealing with that, so I don't want to steal your thunder. But I mean, it's going backwards, and it's going to, we had for a short period much less confusion, and someone has said, no, too clear, let's go back to where it was really unclear.
We're in heated agreement on that, Tony. It is a step backwards. So let's explore those themes. But let's start, Tony, with you. Workplace delegate rights. It seems that a deliberate design feature of this legislation is really to arm the union movement with tools to enhance their capacity to return to sort of grassroots union organising and probably in an attempt to reverse the decades of decline in union membership density. Tony?
Well, let me get this off my chest straight away because, and I'm sure this will be a theme that recurs as we do a number of these presentations, but this is about, well, the legislation, the little pithy little title is closing the loopholes. There's no loophole here that they're closing. This is the creation of new and extended rights without, as far as I'm aware, any real advance warning about these changes or any consolidated need or requirement for them to be made. So probably really is a justification to enhance the role of unions generally. And in a sense, I can imagine that's part of the general narrative about making bargaining, enterprise bargaining more amenable, more easily achievable. And this is just one of those side issues that's been added on to expand it. And, you talk about data earlier. We know that union membership has it fell off the cliff years and years ago, and it's falling into the crevice. The union membership generally in the private sector is, I think on the latest data, about 8%. 8% of the private sector workforce. When you take into account the public sector overall, it's about 11 or 12%, right? So we are entrenching within the Act certain rights of workplace delegates, I'll talk about that in a minute, which enhance the role or in fact create a role for unions in every single workplace. So I can go on about that a little bit more. The fundamental changes are these. Number one, every modern award must include a workplace delegate's term. And that is, it must provide for the rights of workplace delegates within every employer. And similarly, any workplace determination, or more relevantly, any enterprise agreement needs to have a workplace delegate's term. And if the term is not as favourable as that exists in the award, then the award will automatically replace it. And it's up to the Commission to determine the rights in each workplace delegate's clause in each award. And the explanatory memorandum deals with saying, well, in some cases, in some industries or some sectors, the delegate's term may be different to what it is in other clauses. So you might have offshore drilling or mining or FIFO workforce, which requires, at least in the Commission's view, a more rigorous clause dealing with workplace delegates' rights.
But there'll be some time before all that happens, won't there, Tony? Because, of course, I think the deadline for the modern award terms is 1 July 2024.
1 July 24.
And then, consequentially, the obligation to include them in EAs only applies to votes that commence post 1 July 2024. But there are some rights that commence more immediately, aren't there, on royal assent?
Yeah, well, the act, whenever that is, and we don't know what the timing is going to be on all of this, and depends on the Senate outcome as well, because even the 1 July prospective commencement of the award rights may well push out. So who knows? But most importantly, there are changes to the general protections laws. So what that means is it fills what the EM at least says is a gap in the sense of the rights of a workplace delegate to be protected from adverse action in relation to their performance of their role as a workplace delegate, which, by the way, isn't expanded upon. But can I just go back and say, what is a workplace delegate? Because a workplace delegate under the legislation is someone who is appointed or elected under the rules of the registered organisation, which is a union. So contemplate this. Any person who is elected or appointed as a union delegate automatically has rights to represent any other member within their employer, but also anyone who is a prospective member, so someone who is eligible to be a member of that union. And that's quite a considerable expansion of what we currently have. And because that means in bargaining, for instance, I'm jumping around a bit, Rohan, but it means in bargaining that if you have let's say a medium-sized business, you've got 100 employees, you have traditionally enterprise bargained with your workforce, you don't have a role with the union probably doesn't, let's say has no members or has 1 or 2 members and has a kind of sporadic interest only in bargaining. Once you've got one member, one workplace delegate, they can act on behalf of any other members, if there are any, but they also can represent the industrial interests, whatever those are. That term isn't defined quite easily in the Act, actually. Represent the industrial interests of non-members. And that can mean, I can go on in a minute and say what that means in terms of some of the rights.
Let's dig into what that means, because I think that's the real trick here, because there is some grey around the edges on this. So let's assume there's a workplace delegate in the workplace. There's at least one member, maybe hundreds of potential members.
Yes.
What are the new rights that are afforded to that workplace delegate?
Well, first of all, the employer has to recognise their role, and they can't treat them adversely as a consequence of them exercising those rights, save that the explanatory memorandum refers to an exclusion about an employer being able to, conduct reasonable management action in relation to the performance of the role. But interestingly, the workplace delegate has certain rights to communicate with their members or persons eligible to be members. It doesn't, on the other hand, create a right for non-members to be represented, but nevertheless, the workplace delegate can seek to represent their industrial interests. And it means on work time that the workplace delegate could say, there's an issue over in plant B, I'm the workplace delegate, I need to go over and represent them. And the employer will then say, well, hang on, I need you to do your job here, fixing the widgets in plant A, you can't go. And therefore you'll get a question about what is reasonable. Because right throughout the legislation, there are references to the eligibility for the workplace delegate to undertake tasks, or I should say, an onus on the employer to provide reasonable access, reasonable facilities, and reasonable opportunity for the workplace delegate to perform their role. And what's reasonable is a test which is going to depend on the size, the nature, and the resources that are available within that particular enterprise.
Well, it's fertile ground for disputes, and
yes.
It's going to be fascinating because in developing those modern award terms that you've mentioned, the Fair Work Commission is going to have to look at these workplace rights and use them essentially as the base to develop those terms. So it's going to be quite interesting to see what view the Fair Work Commission takes about the boundaries of these rights. But just to refer to some of the specific words used in the legislation of those rights you mentioned, Tony.
Yeah.
Employer must not unreasonably fail or refuse to deal with the workplace delegate. So if they turn up in a performance or disciplinary discussion as a representative in a disputes process, insert long list of other scenarios, probably an obligation to deal with them.
Well, and the onus is on the employer to disprove the breach.
Correct.
So if the employee or workplace delegate says, well, I wasn't provided with the reasonable facilities, or I wasn't given the reasonable opportunity to perform my role, then the onus is on the employer to disprove the breach of the adverse action.
The other one is that the employer can't unreasonably hinder, obstruct, or prevent exercise of these rights by the delegate.
Yeah.
The boundaries of this are just quite unclear.
Or they can't communicate or misrepresent their rights as well. So if an employer is naively aware, or maybe even wishes to say, no, you're not allowed to go, I'm not going to allow you to go, you can't represent their interests, then that's a potential misrepresentation, which are accompanied by quite significant civil penalties, as already exist under the workplace rights provisions of the Act. So it's going to be a new area for employers to have to understand to deal with, particularly those where you don't have entrenched union memberships, or where you might have complex issues of demarcations within an organisation and creating workplace delegates in those circumstances, where you might have the AMWU against the ETU against a PESMA. So again, there's fertile ground for disputes in that space as well.
Yeah.
That's right. And do you think, Tony, it's also going to set a minimum threshold for bargaining? So you'll have the award provisions, and do you think the unions will approach that as the minimum in terms of bargaining and end up asking for more?
I think that's right. I mean, you can look at it in the same way as a dispute resolution clause. There's kind of a default clause that many employers will adopt. But of course, in bargaining, you get a lot more developments on particular enterprise. So there's no question it's going to be the minimum from which there'll be fertile ground to expand.
I think that's the intent. It will be the general protections provisions we've just spoken about as the base. Modern awards will go a little bit further, and then enterprise agreements will probably go a little bit further again, just by reference to that pressure you mentioned, Luce.
That's right.
But the other thing, these also apply to regulated workers as well. And you referred to earlier, the road transport workers or the gig economy or digital platform workers. And that's going to be really complicated. Yeah. It's not a big area necessarily of our client base, but if you're in the gig economy and you're not used to dealing with employees, let alone unions, and that's going to be a real additional burden. Probably not at all surprisingly. It's going to make it harder for those businesses to survive, and therefore to encourage more regularised employment arrangements rather than gig economy pseudo-employment arrangements.
And another good reason ahead of royal assent to be very clear about how you're going to comply with these new obligations from the start. It's going to require a little bit of advanced thinking, because these are some quite extensive protections.
That's right. And do you think, Tony, I'm just recalling back in the day, some employers ended up with delegates who were, fully paid by the employer, but their whole job was to be a delegate. They'd have their own room.
Yes.
They wouldn't actually be on the tools. Do you think that there's a risk of that returning if employers don't monitor this closely?
Look, I'm always one to pile onto the Commission when I can, but I think, let's face it, there are a lot of sensible men and women in the Commission, and they're going to want to be really careful to prevent this turning into an elaborate monster. Yeah. But there will be attempts by some unions or workplace delegates to expand and expand and expand. I actually see it more akin to the creation of rights more like European Works Councils. But I agree there's a potential for that, but the Commission will have, I think, some significant role in winding that back, or at least I'm hopeful that would occur.
That's right, if the employers challenge it, I guess.
Yeah.
Now, Lucy, speaking of uncertainty, the bill also proposes new employer and casual employment definitions, which really, as you've mentioned previously, appear to be deliberately designed to unwind High Court authority, and I think probably make it a little bit less certain as to what the nature of these relationships are. Do you want to comment on the changes that the bill has made there?
Yes, Rohan, and you've hit the nail on the head. These changes are about turning back time effectively. In the past few years, as you know, we've had a few seminal cases make their way all the way to the High Court with Rosato on casual employment and personnel contracting and JAMSEC on the employment status definition. And what those cases did is that they confirmed the primacy of the contract in how a working relationship is characterised. Essentially, what's set out in the terms of the contract was the most important, and the way that the parties then conduct the relationship had less relevance. So clearly for employers, that provided a lot of certainty and mitigated a lot of compliance risk as compared to things of the past when you looked at the conduct of the relationship post that contract. Perhaps, unfortunately for employers, the bill proposes to undo that work. So in relation to casual employment, it does three key things. First, it creates a new definition of casual employment, which is where there's an absence of a firm advance commitment for continuing an indefinite work, and that involves looking at the totality of the employment relationship and not just the contract. Second, it introduces a new employee choice conversion regime, which will sit alongside the existing casual conversion provisions in the Act. Lastly, it introduces an obligation on employers to issue a casual employment information statement, not just at the start of the relationship, but 12 months from the anniversary of the start date. And, that's really designed, as a lot of measures in the bill are, to educate employees and ensure that they're aware of these new pathways to secure permanent employment. Turning to the employment status definition, it's a similar path it has taken. The bill intends to introduce a new ordinary meaning, they call it, of employer and employee. And again, it's moving away from the terms of the contract and looking at, the practical reality of the relationship more broadly.
But before we get to that change, the definitional change is just to the ordinary meaning definition. Are you able to comment on what that means, Liz?
That's right, Rohan. So it's just the ordinary meaning definition. So employees who otherwise are not national system employees, say, for example, state people who work in the state government section, won't be impacted by these changes and will still continue to be covered by the common law tests from JAMSEC and personnel contracting.
Yeah, so importantly, it doesn't impact the national system employee-employer definition in the Act, and different divisions and sections of the Act utilise different definitions. It's an important complexity in all of this that you'll need to consider in application. But leaving that to one side for a moment, the change to the ordinary meaning definition, what will that mean practically? What do employers need to do we think, if this change takes effect?
Well, it's a return to, what's old becomes new again, as Tony said. So it's the multifactorial test that we're all familiar with from a few years ago. So we'll be looking at when a court is assessing a relationship, they'll look at a number of factors such as how an employee is paid, how they pay tax, the element of control, and whether they can delegate their work. So it's not a hard and fast rule as to whether someone's an employee or a contractor. Which is intended to create flexibility, ensure that relationships, the way they're run is reflected appropriately and is not just based on the contract. But unfortunately, that flexibility creates uncertainty for employers and a significant degree of compliance risk. So businesses will need to be looking at their contractor workforce, conducting audits to ensure that if an employee, if there's a contractor, that they're truly a contractor with reference to those factors that I mentioned. And the risk and consequence for employers is that if someone is, you treat them as a contractor, but they're in fact an employee at law, the risk is that they'll have claims for unpaid entitlements, giving rise to potential underpayments, and also they'll be able to access employment rights, which you may not have proceeded on the basis that they were. So there is risk associated with this. It's a familiar risk of pre-JAMSEC and personnel contracting, but it requires businesses to examine the way they're running those relationships.
Yeah, the audit is a really great suggestion. That's just a tool, I guess, to monitor and make sure that you're treating your workers consistent with how you intend to characterise the relationship. But I think also I'd add to that the need to make sure that onboarding processes are set up in such a way that workers are being engaged through the correct engagement model in the first place.
That's
because
right.
It may be that certain workers that you've traditionally engaged as contractors, that might not actually be appropriate. What you might actually need from the relationship is something that's more consistent with an employment relationship. And if that's the case, then sound onboarding processes should include controls that ensure that those things are assessed and that the proper engagement model is selected. But before you move to casuals, I think there's just one other point I was going to add in, Luce, and that is also a slight change to the sham contracting offence. So misrepresenting an employment relationship as a contracting relationship, slight change to the defence available to employers. It's moving away from the defence of it not being known or not being reckless as to the fact. Instead, it's moving to a reasonable belief test, which to me seems like effectively a raising of the bar to meet that defence. It's going to be harder for employers to roll it out.
And similarly, with there's a new prohibition on misrepresenting the casual employment relationships with the same defence of reasonable belief that it was a casual employment relationship. But I think importantly for a lot of our clients, if for sophisticated big business with internal HR and ER, that's going to be a really high bar to prove.
Yep, agree. On to casuals. So let's dig into that in a little bit more detail. What should employers be looking to do now? Let's assume this actually commences operation. What do employers need to do differently as a result of these changes?
Well, it's similar to the processes you take in relation to the employee definition. So I think businesses need to be looking at their casual labour and assessing the contracts, because the contract is still relevant, but also assessing how that relationship is operating in practice. So whether, the pattern of work, whether there's a regular engagement, whether there's an expectation of continuing work, whether the employer can truly reject and accept work as they please. So all those factors will be relevant. So an audit of those relationships is important, not just prior to the changes coming in, but setting up systems so relationships can be assessed at each point. Another measure which is relevant to the employee definition as well is, I think, education and training for hiring managers. They're not always experts in IR and HR, so ensuring that they're aware of the potential consequences of getting a characterisation wrong.
Yeah. So the point being, we can't take as much comfort in the terms of our contracts anymore in defining the nature of that relationship. So does that mean, Luce, can employees sort of morph between casual and permanent as time goes on? Is there risk of that changing up? How does the bill deal with that?
Well, that was previously the case, but there is a positive development in the bill regarding that. So the bill proposes that an employee remains a casual employee until a specified event. And the specified events, there's 4 of them. They're really clear. So it's where an employee converts to permanent employment under the Fair Work Act's existing casual conversion provisions. It's where an employee accepts an offer other than as a casual employee with the employer outside these regimes. If the Fair Work Commission makes an order that an employee should be a permanent employee as part of the new arbitration provisions. And lastly, if the status is changed in accordance with an industrial instrument. So clearly defined situations, and in each of those situations, an employer will have advance notice that determination can be made.
And how does all this interact with the existing conversion provisions? There are some new provisions in the bill that provide additional mechanisms for employees to make known to their employers that they would like to convert or become permanent. Are you able to take us through that, Luce?
Yeah, sure, Rohan. So the existing Fair Work Act provisions, so firstly, the provisions will interact together. They're supplementary rather than repealing one another. The existing Fair Work Act provisions provide that an employer must make an offer of permanent employment to a casual employment if certain conditions are met. So that's been 12 months and they've been working in a regular work pattern. And then there's residual rights for an employee to request that conversion after that 12-month period. The difference with this new employee choice framework is that it puts the power in the hands of the employee, and that's, part of the whole intention behind the legislation is to create pathways for security of work for employees. So the employee choice framework allows an employee to give an employer a notification if they've been initially engaged as a casual employee, but they feel they're no longer meeting that definition. So it's morphed into that there is a firm advance commitment for ongoing work. So it essentially, like other statutory requests in the Act, allows an employee to put in this request. The employer is then obliged to consider it, to consult with the employee, and then either accept or reject. But similar to the other provisions, it's not just a default reject and you can get away with it. There's defined circumstances for rejecting. So one being that you don't agree that they've become a casual employee. And an employer needs to give detailed reasons if they reject that notification request. There's also a stick as well, in that the Commission's arbitration powers have been expanded to deal with these disputes.
Yeah. This really is closing the loopholes.
Well,
this change, because it's complementary to the changes previously to the fixed term contracts. So whereas now there are limitations on being able to have fixed term or extended fixed term contracts, and now you either need to go on to permanent contracts or permanent employment. Some employers were filling that void with casual employment, and this makes it just harder to fill that void in.
Yeah, well, it's a response to, I think, concern by the government as to the take-up of those conversion rights, and I think the view was that they weren't being exercised as much as the government would like. Now, employer side was saying, well, it's because casuals actually want to be casuals. Yeah, right. There is a choice. Now, we'll soon find out, because, I think that these new changes are designed to really flesh out to what extent do employees who are casuals actually want that arrangement, or do they actually want permanency?
Yeah.
And I think we should add, Luce, I think those new employee choice framework provisions that you mentioned, they don't kick in as at 12 months, consistent with the current conversion provisions. They kick in earlier for most employers, I think at the 6 month mark,
6 months, yeah.
But 12 months for small businesses.
That's right. That is a key difference as well.
Yeah. So I think, look, in all, there's a lot more regulation there, isn't there? And I think it is fair. I'm going to use the word uncertain, because I think if there's primacy given to contract and the way the parties have said that they intend the relationship to operate, that is necessarily more certain. This requires a whole bunch of other factors to be assessed in making these calls, and a whole bunch of additional processes to follow in order to ensure compliance. So unfortunately, more work, more time to be invested in this by business. And in many respects, probably more lawyers as well, given the disputes that will float through the Commission and the courts.
I agree.
Just a quick question. What happens to the 25% loading that you have when you're a casual and you convert?
That is the second part of the definition. So there's the firm advance commitment for ongoing work, and that the employee receives a loading. So, previously that was the product of an industrial instrument, but now if someone's truly going to be a casual employee, it's required in the contract of employment if they're not otherwise award or EA covered.
Yep.
One final question from me without notice, and I'll ask it to...
You're not suggesting this is scripted, are you?
No one would have thought that, Tony. And I'll ask each of you, just in case you have different views on
Tony
this.
can go first.
All right, I'll start with Tony. Tony, thinking about the changes that Lucy just talked through, changes in employment definition and casuals, do you think that is going to incentivise businesses to move a large proportion of these people to direct permanent employment?
Well, actually, I do. And that's achieving the objective. Look, I think they'll do so reluctantly because employers want as much choice as they possibly can have in those circumstances. But we've seen with the changes on fixed term contracts, it's pushing employers in a particular direction, and this is also pushing them in towards another direction. Now there is clearly a business need for casual labour. And I think what the government is saying is in these changes is when you genuinely need casual labour to fill voids in production or certain gaps, that's when you use casual labour. But if you're using casual labour for other purposes, really to have inherently the inflexibility that you want over long term, then you're going to have to be curtailing that. I think employers are going to respond that way.
Lucy, your thoughts?
I agree with that. I think particularly in relation to the contractor employee definition. For casual employees, the new specified event regime provides some comfort, particularly in relation to past compliance and back payment liability. But I think it's not total comfort because there's the misrepresentation provisions. So if you've mischaracterised a relationship from the start, there will be liability and it's a civil remedy provision. So, I think it is, as what it was intended to do, driving employers to grow their direct employment, permanent employment workforce.
Well, that certainly seems to be the intent. It's going to be fascinating to see how all this plays out. There's a lot more on this, including in relation to the casual employee definition in our comprehensive summary on the bill. So again, Google HSF and closing loopholes to get access to that. And so there we have it. Tony, Lucy, thank you for your contributions today. Some more really significant reforms that are going to change the industrial relations landscape in Australia if they do commence. Look out for our next episode on closing loopholes, which will cover the remaining big ticket items, including the new federal criminal offence of wage theft. So as always, we'd love to hear feedback from you on Inside IR. Feel free to comment, send us an email or direct message. Email is insideir@hsf.com. Otherwise, thank you for joining us and we look forward to seeing you on our next episode of Inside IR.